Welcome to our presentation on the interpretation of contracts representing Germany. First, we will outline the main concepts. Then, we're going to be comparing Germany, France, and England in the areas of intent, good faith, and contra preferentum. We will continue with the European legislation and lastly discuss the solutions taken by the CECL, the PECL, and the DCFR.
The main concepts of contract interpretation. First, we have intent. Intent is what the party means by the words of the terms in the contract. Secondly, we have good faith. In contract law, the implied covenant of good faith and fair dealing is a general presumption that the parties to a contract will deal with each other honestly, fairly, and in good faith, so as to not destroy the right of the other party or parties to receive the benefit of the contract. Thirdly, we have contra preferentum. This rule entails that an ambiguity in a contract must be interpreted against the person who drafted it. This gives a clear incentive to the drafter to put the contract in clear terms, providing deterrence against sloppy drafting. Intent. Intent in Germany. Germany has a subjective approach, as we see in paragraph 133 of the BGB. When a declaration of intent is interpreted, it is necessary to ascertain the true intention rather than adhering to the literal meaning of the declaration. Intent in France. In France, we have a subjective approach as well, as seen in Article 1156 of the French Civil Code. In France, the idea of moral individual as a self-governing agent is a building block of the entire law of obligations. Intent in England. England is objective. In English law, an interpreter of a contract is expected to establish mutual intention of the parties on the basis of the document itself. The wording of the provision has to be understood according to its plain and literal meaning. Not possible to construe the contract in a matter that runs against the language.
Good faith. Good faith in Germany. According to section 157 of the BGB, contracts are to be interpreted as required by good faith, taking customary practice into consideration. Section 138 of the BGB considers null and void any legal act contrary to accepted standards of good behavior. Furthermore, Section 242 of the BGB establishes the obligation to execute contracts in good faith. However, in practice, German judges cannot judge in equity using paragraph 242. This paragraph does not constitute a legal basis upon which to act, nor does it have direct legal effect. Therefore, in German law, the principle of good faith does not constitute a general autonomous legal basis. Good faith in France. In French law, all legal agreements must be formed in good faith, according to Articles 1134 and 1135 of the French Civil Code. However, despite the fact that these articles specify that agreements must be executed in good faith, it is difficult to understand precisely the scope of the notion of good faith and contractual loyalty. Therefore, in practice, it is difficult to defend the idea that contractual good faith is vital for French contract law. Good faith in England. As to English law, England has not legislated on good faith. In the same way as French law, English law does not set out good faith as an essential condition for the conclusion of a contract. Yet, doctrine of equity is used as a tool by which legislators can protect the weaker party in contractual relations. By interpreting agreements, English law favors literal interpretation over examining the psychology and the real intentions of the parties. However, good faith recourse is available for contract resolution in the case of non-performance of an agreement or when a co-contractor refuses to divulge important information about his or her co-contractor. Furthermore, a good faith notion does exist in certain types of contracts, notably in trust law.
Contra preferentum rule. Contra preferentum rule in Germany. In Germany, there is a mandatory protection for the weaker party in the case of ambiguous terms, as outlined in 305 of the BGB. Ambiguous terms are interpreted against the party who drafted them. Contra preferentum rule in France. In France, there is a mandatory protection of the weaker party, as there is in Germany. We see this in Article 1162 and Article 1602 of the French Civil Code. Contra preferentum rule in England. In England, there is case law, Davies v. William, which says, words are to be interpreted most strongly against him who uses them. This is the same as in Germany and France.
As to the European legislation, we have the Unfair Terms in Consumer Contracts Directive, where principles such as good faith and the Contra preferentum rule are covered, and the Self-Employed Commercial Agents Directive, where the principle of good faith is covered in Article 3 and 4.
The last point deals with the solutions taken by the CESL, PECL and DCFR. As regards intent, according to the CESL, a contract is interpreted according to the common intention of the parties, even if this differs from the literal meaning of the expression. If one party intended for an expression to have a special meaning, and the other party knew it at the moment the contract was concluded, or could have been expected to be aware of it, the expression is interpreted according to the first party. If no intention follows from the first or the second, the reasonable person standard is applied. This is virtually the same for the PECL, as enshrined in Article 5:101. The DCFR also deals with it in the same way, although it contains an extra clause. The reasonable person standard is also applied when the dispute arises with a non-affiliated third party. Coming to good faith. The solution taken by the CESL regarding the good faith principle is almost identical to the PECL and the DCFR. All three instruments require good faith to be taken into consideration when interpreting a contract. Coming to the Contra preferentum rule. The CESL contains a rule which requires the interpretation in favor of the consumer. It reminds of the concept of the Contra preferentum rule contained in the PECL and the DCFR, which means that the interpretation goes against the stronger party who would profit most of it. As Article 64 only refers to B2C contracts, Article 65 covers the other types of contracts. The core content is the same, namely that the term should be interpreted in favor of the weaker party. The CESL seems to have adopted the approach of the PECL and the first part of the DCFR in this case, meaning that the interpretation goes against the supplier of the contract term. Moreover, the CESL has added a clause within Article 64 prohibiting the exclusion and modification of the aforementioned article to the detriment of the consumer.
That's it, ladies and gentlemen. Thank you for your attention. Bye!